Good afternoon. My name is Meghan Connolly. I'm an associate attorney here at Seacrest Wardle. I'm here today with executive partner Jim Bradley to talk to you about the interplay between PIP and workers' compensation. I know as an adjuster, I didn't anticipate this coming through very often, but I was quite surprised to find out how many times the workers' compensation would come into play, or there would be a question of whether the workers' compensation should be paying on some of the claims. So the intention of our presentation today is to just go over some of the basics with you about no fault and workers' compensation and tell you a little bit about how these two will work together in order to determine potential exposures for both the PIP and the workers' compensation claims. So quickly, what we will be covering is the statutory schemes for both the workers' compensation and PIP, how to qualify for benefits under either, the benefits available to an injured party, the set-offs that are available and the appropriate application of the set-offs, and what to do when legal action occurs. As most of you probably already know, the no fault is governed by MCL 500.3101. In Michigan, all vehicles that are being operated within the state for a period of at least 30 days within a calendar year are required to have the no fault coverage. The minimum coverages required by this act are the personal injury protection, which we know better as PIP. That does provide unlimited coverage for injuries related to a motor vehicle accident. You're also required to have property protection insurance, or PPI, which provides coverage up to $1 million for fixed property damage. Both of those PPI and PIP coverages are available to the injured party and any property damage regardless of who is at fault for the accident. Finally, there is a requirement for residual liability insurance for both bodily injury and property damage. In bodily injury, the minimum coverage required is $20,000 per person, $40,000 per occurrence, and the minimum coverage for property damage is $10,000. Generally in Michigan, because of the PPI coverage, you don't see payment coming out of the property damage section. This is generally seen more if you're in an out-of-state accident, or potentially if you're involved in an accident with a federal vehicle such as a mail truck. Workers' compensation is governed under MCL 418.101. The workers' compensation coverage is required for all employers, and we've provided a list of the requirements for the employers. There is the opportunity for an employer to be self-insured, or they can opt out, but they have to fill out the appropriate paperwork with the state in order to get this waiver. Notably, neither the no-fault statute nor the workers' compensation statute specifically discuss the other to determine any sort of offsets available. So we do need to look to the wording of the statute as well as the case law when determining what, if any, interplay is between the two, as well as any potential offsets. Next, we want to talk about how you qualify for benefits. Under the no-fault scheme, it is required that the injured party sustain an accidental bodily injury arising out of the ownership, operation, maintenance, or use of a motor vehicle as a motor vehicle. A motor vehicle is described in the statute as well as a vehicle, including a trailer, that is operated or designed for operation on a public highway by power other than muscular power and has more than 2 wheels. So obviously motorcycles do not count as a motor vehicle in this instance. There are also some exceptions for when a vehicle is actually parked instead of in a motor vehicle capacity. So we look to MCL 500.3106 for those exceptions. In order for an injured party to qualify for benefits under workers' compensation, they most importantly must be an employee. So an employee is outlined in great detail in MCL 418.161. A bigger question comes up, especially in trucking type cases, which we'll talk about later, as to whether a person is an independent contractor versus an employee of the company. So in order to determine whether a person is an independent contractor, we do use the economic reality test, which is outlined on the slide for you. Some other considerations besides those that are listed would be to determine whether the injured party is receiving a 1099 from the company or whether they are receiving a W-2. As a 1099, they generally would be seen more as an independent contractor. Another consideration is if there's any sort of written agreement between the parties that may outline whether a person is an independent contractor versus an employee. The workers' compensation statute does provide a little bit broader sense of injury for an injured party. A person may be injured in the course and scope of their employment, which could be one specific incident, or it could be if part of their work contributes to or aggravates some pre-existing condition. Additionally, if there's a mental disability or conditions of the aging process, such as heart or cardiovascular conditions, degenerative arthritis, those would be compensable if the job contributes to or aggravates or accelerates the condition. There are also some limited circumstances in which a person may not be technically working their intended shift, but they may still be considered in the course and scope of their employment. This is outlined in the statute under MCL 418.3013. Now I'm going to hand the presentation over to Jim Bradley to tell you when you will see some overlap between the workers' compensation and the PIP. Also discussion regarding the benefits available under both statutory schemes and some potential set-offs that may be available.
Thank you, Megan, and good afternoon to everyone listening. Obviously, one of the unique characteristics that we're here to talk about today is the interrelationship between workers' compensation and the Michigan no-fault statute. And of course, that interplay starts with an analysis of who is in the first order of priority and making the first payments of benefits to an injured claimant. The Michigan no-fault statute is fairly clear that in cases of individuals either operating employer-owned vehicles or in cases where they're using their own vehicles but are engaged in the business of their employer, that the workers' compensation carrier is in the first order of priority. This is found at MCLA 500.3114. Consequently, the analysis starts in every case with a determination of whether workers' compensation or no-fault controls. But even if workers' compensation controls, there are unique aspects of the Workers' Compensation Act which can return coverage back to the no-fault carrier. This is particularly true in trucking cases where the industry today finds most truckers to be independent contractors and not employees of the employer that has hired them to perform the overland cargo hauling. The recent Michigan Court of Appeals case of Adenalik versus Harco is a good example of that. And in trucking cases, we would note that the economic reality test has to be a starting point for every analysis of a claim involving a trucking accident. Again, the McKissick case outlines the specific economic reality test factors, and they should be analyzed to determine whether or not the truck driver at the time of the accident was an independent contractor or an employee of the employer to whom they're driving the truck. Generally speaking, truckers own their tractor and may or may not own was in the highest order of priority. Obviously, priority would return to that no-fault carrier, but only in the event that the independent contractor had a personal policy of insurance. If they don't have a personal policy of insurance, the priority scheme returns to the employer and workers' compensation would control. Obviously, these trucking cases can become increasingly complicated, and we welcome any questions or comments that you might have on this particular issue in the event that you're writing commercial policies. Now, once you've made a determination of who is in the highest order of priority, the next question involves payment of benefits. And it is notable that benefits are not the same for workers' compensation as they are under the Michigan no-fault statute. Under the no-fault statute, specifically MCLA 500.3107, benefits include medical bills for the life of the claimant, attendant care, both friends and family, as well as agency benefits for the life of the claimant, and vocational rehabilitation to the extent necessary. No-fault benefits also include wage loss calculated at 85% of gross wages, These are obviously different calculations and can create tabulation errors, especially during the first 3 years of recovery, since wage loss benefits under PIP are capped at 3 years of reimbursement. Obviously, the PIP carrier does not owe any differential outside of the 3-year statute. It is noteworthy that replacement services are not recoverable under the Workers' Disability Compensation Act. As such, there will never be any set-off for replacement services. The PIP carrier will always be in the highest order of priority and will be responsible for benefits up to $20 a day for the 3 years immediately following the motor vehicle accident. In the case of attendant care, there is an entitlement to recovery under the Workers' Compensation Act found at MCLA 418.315 paren 1. However, this benefit is capped at 56 hours per week. As in the case of medical expenses, this constitutes a set-off against family and friends attendant care provided for under the no-fault statute. There is no limitation on agency-provided attendant care under the no-fault statute, but attendant care would be capped at the rate provided for under the fee schedule. If agency-provided attendant care is required under the Workers' Compensation Act, there would be no duty to pay under the no-fault statute. But if the no-fault carrier paid attendant care at an agency rate, they would only be entitled to reimbursement from the workers' compensation carrier up to the amount of the fee schedule. Now, in the case of no-fault claims, resolution results in a settlement or a judgment. In the case of a workers' compensation claim, it results in a redemption. A redemption occurs when a hearing is held before a magistrate who determines that the amount of money being paid for by the workers' compensation carrier is appropriate and meets the standards and intents of the Michigan Workers' Compensation Act. Parties cannot enter into a private settlement absent approval of that settlement by a magistrate. That approval occurs during a redemption hearing when the claimant outlines under oath what is being received and the magistrate approves that amount. In the case of a redemption, if the claimant, quote, redeems, close quote, his medical bills, the no-fault carrier is entitled to the protections of the redemption and would not owe any additional medical benefits that could have been covered by the Workers' Compensation Act. This is also true with regard to family and friends provided attendant care, as well as agency attendant care. Now, unlike medical expenses, wage loss reimbursement is complicated and sometimes difficult to calculate when there is entitlement to wage loss reimbursement under both the Workers' Compensation Act and the Michigan No-Fault Act. As noted, the calculation differential is all that is owed by the no-fault carrier. Stated differently, the no-fault carrier is required to pay 85% of the gross wages, less any and all statutory settlements. However, the statutory settlements entitled to the no-fault carrier are not identical to the statutory settlements that are available to the workers' compensation carrier. For instance, the no-fault carrier is entitled to a set-off for Social Security disability benefits applied for and received by the plaintiff, so long as the disability relates to the automobile accident. No corresponding Social Security disability set-off is available against the workers' compensation benefit. As such, good handling dictates that the workers' compensation claim be initiated first, followed by the Social Security disability application, thereby entitling the no-fault carrier to maximize set-off potential. The no-fault carrier can recommend but cannot require the claimant to make a Social Security disability application, and there is no entitlement under either the no-fault statute or the Workers' Disability Compensation Act for Medicare or Medicaid reimbursement. In addition to workers' comp, there is also a question for no-fault carriers in the case of coordinated policies, and in particular in cases where company-provided medical insurance plans exist. These plans, sometimes referred to as ERISA plans, provide for medical reimbursement, but oftentimes also contain exclusions which can relate to motor vehicle accidents. As such, good file handling always dictates a review to determine whether the policy is coordinated, and if so, whether an ERISA plan exists. If it does, attention should be given to the exclusion portion of the policy, where motor vehicle accident exclusions typically exist. Now, in the case of workers' compensation, as indicated above, Social Security disability does not result in a set-off. However, Social Security old age benefits do result in a set-off, but only up to the amount paid by the claimant themselves, period. This 50% reduction is available to the workers' compensation carrier, although the employee is not required to apply for Social Security old age benefits, even if they are entitled to same. The one exception is if the claimant has reached 70 years of age. If the claimant has reached 70 years of age, they must apply for Social Security old age benefits pursuant to the dictates of the Social Security Administration. In that instance, the workers' compensation carrier can require application for old age benefits and claim the set-off outlined. In addition to the old age benefit, the Workers' Compensation Act also provides for set-offs for wage continuation, typically found in short-term and long-term disability policies, and also pension and retirement payments received by the employee. However, the employee again is not required to retire early, even if their benefits are vested, solely for purposes of providing the workers' compensation carrier with an appropriate set-off. Like Social Security, the one exception involves pension requirements for mandatory retirement at a particular age. In those instances, the workers' compensation carrier can require pension application and make the appropriate coordinated set-off. So in summary, when you have workers' compensation and no-fault entitlement, the analysis begins with a determination of who's primary. In most instances, the workers' compensation carrier is primary, but there are subtle distinctions, especially in trucking cases or in instances where people are driving their own vehicles as independent contractors. Attention should be given to the ad-analytic case to determine what constitutes an independent contractor and under what circumstances does the priority scheme return back to a scenario where the no-fault carrier would be in the first order of priority. Now, in the instance where a workers' compensation carrier is primary, there still can be no-fault carrier responsibility, especially in the case of differential payments for wage loss and family-provided attendant care. There should be no consideration of wage reimbursement for replacements, or there should be no consideration for no-fault set-off for replacement services, since the Workers' Compensation Act does not provide for recovery in the workers' compensation forum for replacement services. Those are solely a no-fault benefit, and there is no coordinating set-off available to the no-fault carrier. Finally, when calculating the wage loss reimbursement, attention should be given to not only a correct initial calculation of an average weekly wage under the Workers' Compensation Act, but also consideration of the manner and amount of set-offs available under each act. They're not the same, and good handling practice would suggest the workers' compensation claim always be handled first. In the event that a PIP claim has been filed, when there is workers' compensation benefit capability, a stay of proceedings should be requested in the no-fault claim on the basis that proper calculation of recovery under the PIP claim requires an initial calculation of recovery under workers' compensation and a coordinated set-off of the various benefits. At this time, I'm going to return the discussion to Meghan Connolly for the remainder of our presentation.
Lastly, we are going to talk to you a little bit about things to consider when legal actions are pending. As you likely already know, the no-fault cases are filed in circuit and district court depending on the amount of outstanding benefits. The plaintiff does have the benefit of choosing their venue at the time of filing for a PIP case, and the statute of limitations is outlined in MCL 500.3145. The carrier must receive written notice within 1 year of the motor vehicle accident, and once that notice has been received, the plaintiff has 1 year from the date the benefit is incurred in order to collect on those benefits. Conversely, in workers' compensation, when there is a claim, it is filed through the Workers' Compensation Tribunal in Lansing. All of the cases are sent directly to Lansing, and then the tribunal will assign the case based on the county. And there are currently tribunals in Detroit, Pontiac, Saginaw, Grand Rapids, and Lansing that are taking new cases. This has shrunk from a much longer list, so you may have seen some in Flint. I believe that they are also trying to just cycle those out. The statute of limitations is also a little bit different for workers' compensation. The employee must give written notice within 2 years of the accident, and once that notice has been received, the employee can only collect for back benefits within the 2 years preceding the date of the application. The one difference is that the payment for nursing or attendant care is only limited to 1 year from the date of the application instead of that normal 2 years. These statutes are important to consider, especially as a no-fault carrier that may need to intervene or file into the Workers' Compensation Tribunal for those benefits. This is just another thing to keep in mind if there is a question as to whether there are workers' compensation benefits available to an injured party that is collecting PIP benefits. As I've sort of already hinted to, if the no-fault carrier does make a payment on a claim and then later realizes that the injured party was in the course and scope of his employment, the no-fault carrier may file a claim in the Workers' Compensation Tribunal and essentially stand in the shoes of the injured employee. They do encourage, or I would encourage, that as a no-fault carrier, you continue to determine whether you're going to be paying benefits and attempt to not delay or refuse to make payments while waiting on that determination through workers' compensation. Some of the cases through the tribunal will move fairly slowly, so those delays could become detrimental to the no-fault carrier. In the case where you have cases pending in both workers' compensation and in circuit or district court, it may be beneficial for the PIP carrier to request a stay on their proceedings until the determination has been made by the Workers' Compensation Tribunal for the determination of any potential offsets that they may receive. This determination for a stay will be at the discretion of the judge, but if you are able to get it, it will definitely be helpful so that you have a solid number as to what the potential offsets are for the workers' compensation. With that, we conclude our presentation for you. We'd like to thank you for spending some time with us this afternoon, and we do welcome your questions. So if you were unclear or unsure on anything presented, please feel free to contact either myself or Jim, and we'd be happy to discuss any of these matters with you further. Thank you.